So in law school, a law student is going to learn corporate law as the Companies Act primarily. There are subjects which are related to corporate law which you learn throughout law school, but you don't learn it the way they are practiced. Like contracts has a connection with corporate law, Transfer of Property Act has a connection with corporate law, but you don't learn it the way it is practiced. You just learn a few acts. Now, when you actually learn the subject of corporate law, you might be learning Companies Act, which is divided often into two parts. Then you may learn Banking Regulation Act also. Depends on the structure of the law school syllabus for your law school. But so you're primarily learning what's there in the Companies Act as concepts. There may be a huge focus on the separate legal entity doctrine. There may be a huge focus on shares of a company. But what gets missed out, or what needs to also be added to that understanding, is that how does it play out in transactions? Okay, so because otherwise you will experience that this whole separate legal entity discussion is going on for multiple classes and you don't know what its ramifications are. You know that it's a separate body. So if I, as a promoter, I don't if the company doesn't have enough money to pay its debts, nobody can get to me as the promoter. But you don't know that in commercial transactions, banks always take a guarantee from the promoters whenever they lend money to the company, which means if the company fails, the promoter has to pay up the amount from his personal assets because he's a guarantor. In some cases, this arrangement is not insisted upon. It is very rare where this doesn't happen. And in a lot of cases where this doesn't happen, banks take security. Okay, so how does this separate legal entity doctrine play out in transactions? That is not told. For example, if you commit a white collar crime and you commit it in the name of the company, but the police can identify that you as the top management were behind it directly and personally, this separate legal entity doctrine will not stand. Okay, so you can be named in the FIR as the offender even though it was the corporate vehicle that did it. Okay, so your name with the company's name, both of them will be there. So now these are the inside aspects that need to be explained and understood to be able to understand, okay, how is this practical? Okay, and so you learn about shares, you learn about certain registers the company has, you learn a little about articles of association and memorandum of association. But then when you actually start a company, now when you work in a law firm, you will get this mandate that, let's say, a big American corporate wants to enter India and they want to open a subsidiary. Now the challenge is, how do they do that? Your Companies Act definition, your Companies Act understanding will not be sufficient to address this, because they will need to first put money outside India, which will require you to understand foreign exchange regulations on how money comes into India. What is the condition or the reporting for that? Okay. After you've done that, then you will look at what are the procedures required. So simple things like you need to have a director identification number, you need to reserve the name for the company, and there are certain criteria for how you select a name. You need to have a digital signature to get your company incorporated and to be a director on that. These are the preliminary procedural steps. These get missed out. We start a lot of times with the art that draft the articles. But that's not the first step when you start a company. The first step is get your digital signature, get your director identification number, get the name reserved first. Okay.